We'll start with prayer from Senator Watson.
Let us pray. Dear Lord, thank you for looking over us and help us remember as this weekend does of what we're here for and why we're here, and allow us to discern and have quality measures that we will vote on. In Christ's name I pray, amen.
Thank you, Senator Watson. So we have, I've been told, 40 House bills assigned to our committee. And so we're going to try to get through as many bills as we can. We do have a hard stop today at 3 o'clock. If you want to be heard on any of the bills, please sign up down here at these sign-up sheets. And we will start with House Bill 1134. Chairman Administration. We are working off of LC 480522. Thank you for hearing some great bills in your committee today. There's no deal working here between the two of us.
Thank you for having me, Mr. Chairman. So I bring for you today House 1134 is LC 480522. This legislation would give concurrent jurisdiction to the state attorney general to prosecute gang crimes. There's several benefits that this bill would bring. First of all, similar to concurrent jurisdiction that the AG currently has for anti-human trafficking prosecutions. This would allow for coordinated efforts. Oftentimes, these criminal enterprises are multi-jurisdictional. They operate many different counties, judicial circuits, and it requires a coordinated effort. Also, prosecutors who are trained to work these types of cases have expertise and knowledge that can be very helpful in these prosecutions, as well as their investigators, post-certified investigators, which is referenced. Third benefit is the assistance to local DAs in specific circumstances where maybe there's a real gang issue, and that expertise I was referencing is helpful. And finally, the prison system continues to battle gang epidemic, and just to think some of our prisons in more rural parts of the state where potentially gang prosecutions could require a large portion of that local DA's office to prosecute those crimes. To have the Attorney General to be able to really focus on that effort would be a tremendous benefit. So the statistics have been given to me that over 50% of all violent crime in the state is in some way connected to gang activity, which is really it's hard for me to comprehend just how extensive that is. And from my time as a felony prosecutor, I'm familiar with the specialized knowledge required to investigate and prosecute these offenses. And this seems to be a very common sense measure to give law enforcement the tools necessary to meet the gang presence that we're seeing currently and address violent crime throughout the state of Georgia. I'd be happy to answer any questions.
All right, thank you, Chairman Administration. Any questions from the committee? Question from Senator Parent.
Thank you, Mr. Chairman. Thank you, Chairman Administration. Just a couple questions. Do we, I see that on 15 and 16, the Attorney General shall have the authority to employ peace officers. Is that something that the AG currently has? Are there other peace officers operating within the department?
So throughout state government, there are post-certified law enforcement officers who are able to work with prosecutors or work as investigators to provide the responsibilities necessary for investigation. And so the answer is yes. And I'm just thinking of several different state departments currently which have post-certified law enforcement officers working within those agencies and departments. This is something that we discussed in House committee, but often prosecutors who are receiving these files, I failed to mention earlier, but the GBI has a specialized task force to work on anti-gang investigations. So potentially a file were to come over, maybe an arrest is made, and the Attorney General is responsible for the prosecution. Investigators who are post-certified are needed within the AG's office to go out and serve subpoenas, to participate in witness interviews, to provide testimony if needed based upon, say, chain of custody evidence when it was in the prosecutor's office, things like that. And so it's very common, it's required to have post-certified law enforcement officers to carry out those responsibilities, in my view. You want a properly trained officer who knows what they're doing to, say, go out and serve warrants and do things like that, or serve subpoenas, excuse me.
So is the thought that because of the force created over, or the unit created over in GBI, that's why the AG would need to come in to prosecute this, to have sort of like a like department at another state agency or something?
So I would say that's one reason. I just gave a few other reasons, but I agree with you that it does make sense when you have first of all, what we have is multi-jurisdictional crime, and that's why an investigating agency like the GBI, who can work in a multi-jurisdictional fashion to address these criminal enterprises, is appropriate. But additionally, to have prosecutors who can then take those cases and prosecute the crimes in multiple jurisdictions with the same prosecutor and investigators working, I think is appropriate. It does also allow for greater coordination with local DAs because, local DA's office would like to work in collaboration with the AG, or maybe a local case it's determined is really part of a multi-jurisdictional gang issue, and that it'd be more appropriate for the AG to work on the file. There could be coordination. And then finally, a major point is gang activity within the prisons. And I was told, I believe this stat's correct, but it's estimated that 14,000 prisoners in Georgia have some gang affiliation of some sort. And when you talk about numbers and that size, that would completely overwhelm any local jurisdiction's prosecutor's office. And this would allow for the Attorney General to really focus on gang prosecutions in those circuits where the prisons are located.
Okay, thank you. So to that point, do we have anything right now that does allow for multi-jurisdictional prosecution?
Yes, certainly. So as I mentioned a moment ago, anti-human trafficking is...
No, I mean like at the like before we did that for GBI. Sorry to interrupt, but like for complex litigation that's been filed in a lot of different jurisdictions, you often get a multi-jurisdictional conjoined lawsuit. Do we not have anything like that currently in the criminal space in Georgia right now?
So I think the RICO statute is sometimes sought along those lines, but I'll just say I'm not an expert in those kinds of local prosecutions. What we're talking about here, though, is a prosecutor who would be able to work in multi-jurisdiction, in a multi-jurisdiction effort, the same prosecutor. And I'm not aware of that outside of I was talking about the anti-human trafficking dedicated prosecutors. I'm not aware of that. There's some folks in the room who would know, but unless you're sworn in as a local prosecutor by the local special prosecutor, I don't know that you could serve that role.
So like a consolidated case, you'd have to get an appointment and do it through RICO now?
So I think the venue requirements are still going to hold. And by the way, that's unchanged by this. So if there's prosecution is venue is unchanged here. You would just have the ability of the Attorney General to prosecute that crime in the venue where it's proper to do so.
Okay, and I know I'm asking, but can I ask one final question? It's all complicated. I'm learning here, not a criminal attorney. So are you envisioning, or is the intention of this that it could be collaborative with the local DAs? And if so, is there a way to make it where they do all decide to go forward in collaboration, or is this set up where the AG can come in over their objection?
Absolutely, collaboration is part of this. I would say that I think that there is a real opportunity for cooperation and work where either a local prosecutor's office is overwhelmed by the number of cases in, say, that prison example that I gave, or where specialized knowledge and the work of prosecutors, because of their experience or training and possibly the nature of the case being multi-jurisdictional, that collaboration would really make sense. There is not a condition in here that would require that the local DA sign off on it. I think that what's important to recognize is that the Attorney General's office has worked very well right now in the anti-human trafficking prosecutorial ability. We're not hearing about local prosecutors objecting to anti-human trafficking prosecutions that are already taking place by the AG's office, and they have a very impressive track record already of addressing those crimes. So this just makes sense. The gang issue is a major problem for all states. The gang issue is not a urban, suburban, or rural problem. It's an issue everywhere. It impacts all 159 counties, and having the chief law enforcement officer of the state having the ability to prosecute these offenses is very appropriate.
Thank you.
No other questions from the committee. There's no one else signed up to be heard on the bill. What's the pleasure of the committee? We have a motion.
Make a motion to pass.
Motion to pass by Senator Kirkpatrick and a second by Senator Hatchett. Any discussion? All those in favor of the motion, please raise your hand. It is 4. All opposed? 1. Kind of no? Okay, 4-1. The motion carries. And it's my understanding that Senator Kennedy is carrying this bill in the
Yes, sir.
Senate? Okay.
Yes, sir.
All right, thank you. The next bill you have is our annual code revision bill, House Bill 1428, and we are working off LC 338851.
Thank you, Mr. Chairman. Yeah, as we say, the riveting, such an interesting bill we get to consider each
Right.
year. Yes. So what we do is just make corrections, update terminology, address any typographical errors. I'd say just clean up language throughout the bill. The sections track each title that's being impacted, and I would just say it's for consistency, for clarity throughout. There's no substantive changes, and be happy to answer any questions.
All right, any questions from the committee? Senator Watson. There's no one signed up to speak on the bill. We'll take a motion.
Motion to do pass.
Motion to pass
Motion do pass.
by Senator Watson. Is there a second? Second by Senator Calzert. Any discussion? All those in favor of the motion, please raise your hand. It is 5-0.
All right.
And I
Thank you,
think
Mr.
I'm
Chairman.
carrying that one for you.
Yes, sir.
All right,
Please.
thank you.
All right. Thank you, Mr.
Thank you,
Chairman.
Mr. Chairman. Appreciate you. I forgot to recognize a judge we have with us today, someone that's never been here before, first time ever in Atlanta, I think. Judge Burt Guy from Brunswick Circuit. There's no justice in St. Mary's today, but they can wait another day. Happy to have you up here.
Based on the bill you sponsored last year, I've been signing the orders all day.
That's right. Yeah, you're working right now, aren't you? Hearing cases. Good to have you as always with us. All right, next bill on the agenda is House Bill 1088, Representative Gunter. We are working off of LC 441956S, and I believe that this is the same bill that Chairman Mullis brought before us earlier this year. Is that
Senate Bill
correct?
493, I believe.
What was that again?
Senate Bill 493
Senate Bill 493. Is it exactly the same as Senate Bill 493?
should be exactly the same.
All right. Tell us just a touch about what the bill does, and then we'll entertain motions.
Okay, this involves timeshares, and it changes the foreclosure of timeshares from judicial to non-judicial.
All right, did
That's
the bill
basically
pass the Senate?
It's still sitting in the Judiciary Committee, I
Is
think.
it in the Rules Committee? It's passed 47-0.
Yeah.
Do you believe that Chairman Mullis doesn't have the politics to get it passed in the House?
I would say he does, yes.
Okay. I don't wonder why you're bringing it over here if it's already passed. We do have a question from Senator Calzert.
Really, too, one is there a certain personal interest or pride of authorship for you? Because we're backpiled with you guys' bills, and if you want the policy enacted, it's probably quicker to pass the Senate bill at this point.
I think the interests that are wanting this would be happy either way.
Okay. And my second question is more substantive, as this was so just eloquently argued in here by Senator Mullis. It was a ease of foreclosures, and he continued to reference people that have purchased these timeshares and want out of them. I perceive the bill being the opposite. It's the property owner that's trying to steal take the property from the owner that maybe's behind on their payments. Is this for the developer's ease to not have to go through the judicial process?
Right, it's quite expensive to do it judicially, and a non-judicial is a simpler process, easier for them to foreclose on, and less expensive, so yes.
So is the problem being addressed? Is there a lot of unhappy timeshare owners that have stopped making their condominium assessment payments, or whatever you call those homeowners?
I think what I've heard is the original owner has died or deceased, and the family doesn't want to go forward with the timeshare, so they quit paying on the fees that are required, and that's where these start to build up. And because of the expense, it's cost prohibitive for the timeshare business to try and close all those. The one in particular that I have in my jurisdiction in Helen, Georgia, has around 1,100 slots open where they could be foreclosed on, but they just, at an estimated cost of around $5,000 a piece, that's too expensive.
One final question. So what happens if there's a deficiency? Let's say the amount owed is greater than the value of the timeshare. Does this also streamline the ability to get a judgment against these estates or people that decided they no longer want it?
Yeah, I think the owners association would eat the fees that they had on it. But if there's any other lien holders on it, this bill sets a priority for them to be paid out of the proceeds from the sale.
No, but I'm talking about if the proceeds don't cover the debt, like a deficiency judgment or, confirmation procedures and other aspects of property law.
I don't know that that's a real problem with timeshare. Do you know that?
Okay.
No, so there's no fees associated with it. As you said, they're just moving the ones that are dormant into a. We're not just taking them back.
Here, come on up. Introduce yourself.
Tried my best to find this chair.
Tell
What
them
I
who
think
you are.
Vernon Lee.
Yeah.
What I answered last time, I think, with your concerns was what this is doing is simply taking the ones, as he mentioned, that are dormant in his district, and applies the other ones that they're just going to go through the non-judicial process by notification, by 4 weeks of advertising, and then purchasing it at the courthouse. And then any fees, they're not going. So if you were one of those that hadn't paid, you would get the notices and the advertisement. You just let it go, and you don't owe any fees, or you just lose your timeshare week, whatever. That's all.
Right, boy. So my question, though, is let's say I owed your association $10,000. The value of my timeshare is $5,000. You foreclose on it non-judicially for $5,000. You're still owed $5,000.
No, sir.
So there is no deficiency possibility?
Not in this case, no, sir.
Okay, thanks.
None at all.
Any other questions from the committee? All right, no one else signed to be heard on the bill. What's the pleasure of the committee? We have a motion to pass by committee substitute from Senator Watson. Is there a second? Second from Senator Hatchett. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. And my understanding is Senator Hatchett's going to be carrying this. Is that correct?
I have burdened him with that. He's agreed to do it.
He's got a couple others maybe. We'll see. All right. Thank you, Mr. Chairman.
Thank you, Chairman.
Appreciate
Thank
you,
you,
Vernon. All right, next bill on the agenda is House Bill 1188. Representative Lott. We are working off of LC 480518. Good afternoon.
Good afternoon, Mr. Chairman, committee. Thank you for having me here today with all of you. I am here to present 1188. It is a priority for Governor Kemp as well as the GBI and their Crimes Against Children unit. It is substantively 8 lines on that LC. You'll see lines 21 to 25 and lines 44 to 46 that clarify language and code so that each child pornographic image or material and each area of a child that is sexually touched during child molestation acts will constitute a separate offense. Prior to 2018, separate offenses was how these cases were charged, but in 2018, a Supreme Court judgment on a different matter decided that the word any would mean that no matter the number, only one charge could apply. That Supreme Court decision set precedent for the word any and has since been applied to the way in which we charge those accused of child molestation and child pornography. No matter the number of images, 10,000 or more, or the number of body locations sexually molested or penetrated, only one charge could be applied with that new ruling. HB 1188 just clarifies the language so that without question, each body part or image will now be charged as a separate offense. If enacted, this bill would ensure that full accountability is rendered on the criminals who commit these evil acts. I know that I do have speakers signed up as well, and one being on the investigative side and one being on the prosecuting side. So if it were possible to have them heard, they are better equipped to answer some of probably the questions that you would have because they work in the field.
Okay. Let's see if we have any questions first from the committee for you, and then we have a couple people sign up to speak. Any questions for Representative Lott? Senator Cowser.
I'm curious, what is the penalty? The portion of your bill doesn't reflect the what's the penalties for one count of this punishment?
It is my understanding that the maximum is 20 years at this time, but this is still up to the judicial discretion. So even when they go to having each image charged or each violation, molestation and body part charged, the judge still has judicial discretion.
It can still run concurrent, is that?
They can't today, but that is, of course, what we hope to do with.
So why not just increase the penalty from 20 years to 50 years then, instead of having to make it see how many pictures they got on their computer or whatever?
I think that probably would be a better answered by your prosecuting the district attorney that is here with me today, which is Chris Arndt.
Mr. Arndt, want to come on up? Maybe good, so he can directly address these questions. Good afternoon.
Thank you. Good afternoon, Mr. Chairman. I'm Chris Arndt. I'm the district attorney in the Lookout Mountain Judicial Circuit. Do you want me to just start answering that question? Or,
sure.
Basically, the way it is, rather than increasing the punishment, being able to charge each one of the images individually, lets us charge the case as the person commits it. And if you only have a handful of images, that's a different case than the one I just resolved last week, which had 50,000 images. That person needs to be looking at more time than the person that has 5 or 10 images. So I think making the way that Representative Lott has written the bill is the way to address it. And this also applies to acts of child molestation, not just the visual representation of those acts that's in child pornography. And I've been a prosecutor 30 years and started doing child crimes in the early 90s when the images were on Polaroids. And this is a crime that has greatly expanded with digital and with the cell phones. We, again, just pled this case with over 50,000 images, over 1,000 of which were of this defendant had created himself with a female relative. And trying to explain to her mother why, for having these images, he can only be punished once, even though he created over 1,000 of this poor little girl. It was a tough conversation to have. That little girl had attempted to commit suicide. Leading up to trial, we ended up resolving with a plea to life served 25 in that particular case, because we also had charged him with the acts depicted in the images. These pictures also never go away. We had another case from our circuit that has resulted in a series with the National Center for Exploited and Missing Children that has our detectives gone all over the world and testified about the abuse this little girl suffered that show up again and again and again. In fact, she still lives in our circuit and has grown up. And later on in school, one of her classmates finds these images online, and as she's starting to get her life back together, now spreads this information around the whole school, setting her all the way back to zero again. And when we try one of these cases again, the way you have to prove on the child pornography is the jury's got to find, they've got to see the image and find that this meets the legal definition. And it creates, I've had jurors that have been on cases that have come up to me later on and said they still have nightmares over having seen these images in a case from several years ago. This one, again, this person had created some of the images with a female relative, and she was wearing a little Minions t-shirt in one of them, and this juror years later remembered that and says, every time I can't look at that kind of a shirt without crying. So the impact of these crimes is devastating, and we ought to be able to punish these people for what they actually do.
I believe one of the cases that this is in response to is the Ed Volson case. I think, is that the one where the child was touched multiple places by a relative? Is that case?
I believe so. I'm not exactly familiar with this. I know there was a couple of them that came out
Yeah.
right along the same time, and that one wasn't from our circuit, but that is one of the, I don't know if that's the child molestation case or the child pornography
Or the
case.
Scott, the two cases had Scott v. State, and maybe that was the Scott based on Ms. Travis. That's the Scott case. But in my memory of that case, they were not able to charge the individual for separate offenses for the multiple touching, even though it was kind of at one time period, versus being able to charge them separately for each way that child was touched.
Correct.
One evening. Any other questions from the committee? There's two others that want to be heard on the bill. First, Ms. Jill Travis, Georgia Association of Criminal Defense Lawyers. Representative Light, you can step back there for 1 second. You don't want to intimidate Ms. Travis sitting next to her.
We're friends.
We are.
We're friends.
I don't want you hitting her when she's talking.
Good afternoon.
Good afternoon.
Members of the committee, my name is Jill Travis. I'm the Executive Director of the Georgia Association of Criminal Defense Lawyers. And while I'm extremely sympathetic to the images that are now in your mind, right, we don't feel like this solution is necessary because we think the law currently allows for it. How do we get here? The Scott case was one of the cases that is involved in the touching of somebody in multiple locations in one incident. And what the accused was convicted of was touching a little girl in her chest area, her buttocks area, and her vagina area, and actually inserting his finger in 2 locations. Terrible behavior. In fact, that's aggravated child molestation. It could have been aggravated sodomy. It could have been aggravated sexual battery, all which carry life punishments with 25 years. But the prosecutor chose to charge the case as child molestation, which, to your point, carries 20 to serve 5, minimum 5-year sentence. So if the prosecutor had chosen to prosecute it in a different manner, because what you all are wanting to do is you're wanting to increase punishment with the idea that increasing the punishment is going to make the behavior go away. And so far, increasing the punishment doesn't make the behavior go away. In the Scott case, Mr. Scott was sentenced to 80 to serve 40. Because the 3 touches on the one occasion was merged into one count. Now, if this had happened over different days, there could have been different charges. Another adding on of the charges. But he would have faced, just with a merger, a minimum sentence of 12 to serve 10 or 11, or a maximum sentence of 40 to serve 38 or 39. And he was convicted and got 80 to serve 40. So it's not like there's not enough punishment out there. With respect to the imagery, one of the things that we have to look at is technology and how. Many of you, I'm sure, probably get an email with a Dropbox, and you don't know how much is there. And when you open it up, I mean, this could be thousands of images. The way the federal courts do it is it's a crime, and then under the sentencing guidelines, it's increased the number of punishment. To Senator Kauser's point, it's increased the amount of time that could be given for punishment. So we would ask that we leave the sentencing to the judges, that the unit of prosecution and the word any is sufficient, and I'm happy to answer any questions that you might have.
You mentioned the idea of getting a Dropbox of something. You'd have to have the intent, though, to actually possess those images, right? It wouldn't be where you accidentally get an email, you open, you're being charged with this crime.
I think that the language at lines 44 to 46, I would hope that knowingly possessing or knowingly violate those code sections would be involved. That's not there, and I can't answer with certainty whether that's the case. Let's just say you were looking for it, right? I'm going to send you 5 images, and then when you open it, it has 1,000.
Right.
How the issue again becomes, is the punishment that's on the books now not sufficient to punish the behavior? And is increasing the punishment going to change the behavior?
Yeah, but just to be clear, the lines, paragraph 5, 6, 7, and 8 all have knowingly as a requirement still.
That's right.
I understand your argument there that you may have only originally intended to get 5, but you got 1,000, but you still have to show you knowingly possess the 1,000, correct?
I would hope so.
Yeah.
Otherwise, you'll see another appellate case.
Right, it'd go to, yeah, definitely. Senator Hatchett?
Thank you, Mr. Chairman. Thank you for coming to testify. I wanted to just kind of address something you said earlier and ask a question. There was a similar issue with the Coates versus State case about possession of firearms, and the language that statute was written is very similar to the way this one's written. And I guess with the textualism that's coming out across the street here, I'm under the impression and believe that this is necessary to clarify the word any in this statute, just as it was with the firearm statute. Do you have an opinion as far as the language in this code section versus the language in that one and that decision in particular?
The Coates decision was before both Scott and Edvilson and was relied on by the courts. And so, truthfully, your point is if you want to make each act a separate offense, then this would be the fix.
Okay. Thank you.
Mm-hmm.
Here are questions from the committee for Ms. Travis. All right, thank you.
Thank you.
Last person signed up to speak is Brian Johnston with the GBI. Good afternoon.
Hey, good afternoon. Thank you very much. My name is Brian Johnston. I'm a special agent in charge for the Georgia Bureau of Investigation. I'm assigned to the Child Exploitation and Computer Crimes Unit, and I'm also the commander of Georgia's Internet Crimes Against Children's Task Force. So we have a statewide task force that consists of about 280 law enforcement officers and prosecutors across the state of Georgia. Last year, we received and reviewed and sent out for assignment almost 15,000 what we call cyber tips from the National Center for Missing and Exploited Children. A large majority of these cyber tips involved investigative leads on people who possess child pornography images, what we're talking about here today. So we have a big problem in the state of Georgia with this, but we also have a pretty substantial task force in place to address this problem. I can speak from experience in working these investigations and working with the victims of these investigations that each time this image is displayed, transmitted, reproduced, sent to someone else, you're victimizing that child again. And not to get too detailed on this, but these are images of child rape, just to put it very bluntly. And these victims deserve justice for each and every count, for each and every depiction, and for each and every time that they have been abused. And I can speak from experience on that and seeing just the vast number of cases that come across our desk, and that are worked by the great, men and women in law enforcement and the prosecution offices throughout the state of Georgia. I'm happy to answer any questions.
Any questions for Mr. Johnston? Well, thank you for what you do, and thank you for being here today as
Thank
well. Leader Lott, do you want to come back up? Any final questions for the author on House Bill 1188 from the committee? Do you have anything else you want to add
I
for
do
me?
not. Thank you for your time.
All right. No one else signed up to speak. What's the pleasure of the committee? Motion to pass by Senator Hatchett. Do we have a second? Second by Senator Kauser. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. And I believe Senator Hatchett's going to carry this one as well.
Correct.
All right.
Thank you, committee.
Thank you. All right, last bill on the agenda is House Bill 620. Representative Leverett, and working off LC 413213S. And remind us, we dealt with this bill last year. Is this the exact same version? Or is this substitute different from what we passed out last year?
Yes, Mr. Chairman, members of the committee, good afternoon. Thank you for placing this on the agenda. It is substantively the same as what this committee passed last year. As Yogi Bear said, it seems like deja vu all over again being here, but we appreciate your action on this last year. We're basically just increasing the cutoff at which a parent can settle a claim of their child from $15,000 to $25,000, and we're trying to clarify the law, because the statute right now, while changing that number is very helpful, the statute's a little confusing. So we did make a few changes to the bill, or to the substitute the committee approved last year after some comments from judges and other interested parties over the summer. And I can go through those changes if you'd like, Mr. Chairman, but they are the only sense they are substantive is that they try to expressly state that which was, I think, implied and understood in the statute.
All right, we do have one person signed to speak on the bill. Any questions for the author first, though? Senator Cowsert.
We're trying to keep from drowning with all the volume of House bills, and so I haven't read every word of your substitute, but is this the one about structured settlements?
It does involve structured settlements, yes, sir.
Okay. What was the rationale for increasing the level for court approval from $15,000 to $25,000 if the reason for the bill is to protect children?
Well, I think there were two reasons. One is we felt that it was more protective of children to try to increase the odds that the settlement of a smaller sum would not be consumed in court costs and bonds and attorney's fees. And secondly, there was a sense that the last time the amount had been changed was, we believe, at least 16 or 18 years ago, and due to inflation and other changes, it would be appropriate to raise it just to keep it consistent with the policy expressed by the initial changes many years ago.
I'm just not familiar in my practice with ever seeing a structured settlement as small as $15,000. I mean, those are typically hundreds of thousands of dollar settlements, not little, small time.
Well, I think that's a good point. I mean, I think a lot of those aren't. If the money's big enough, they're not going to qualify for what I would say the safe harbor of the parent being able to settle. But I would note, and I hesitate because this may cause the senator to have a greater concern about the bill than he already has. But there is a definition in existing code of gross and net settlement. And we're, I believe, clarifying here that the present value of a structured settlement that is to be paid after the majority of the child would not be necessarily considered in determining the value for purposes of deciding what level of approval you have to obtain. I believe it's sort of a sliding scale. If the gross settlement is less than 25, a natural guardian, that is a parent, can settle the claim. That is, enter into an agreement by the time the statute runs and receive the money without any other kind of approval. If the gross settlement is more than 25, but the net is less than 25, then the natural guardian has to get court approval, but doesn't have to be appointed conservator. I may be getting that backwards, but I believe that's correct. Let me just check, if you'll bear with me. Receive payment, hold, use for the benefit of the minor with pro settlement is more than 25, net's 25. That's right. It has to be approved by the court, but the parent does not have to become a conservator. And if both are over 25, then you've got to be appointed conservator, even if you're the parent, and also get court approval.
One final question, Mr. Chairman. All right, so let me make sure this new law would then make it any settlement on behalf of a minor child entered into by the parent or their guardian for $25,000 or less would not need court approval. You wouldn't have to qualify as the guardian or can file the annual reports of what you do with the money.
That's correct.
And
if I might add, we did, because of the concern Your Honor had expressed last year, we did add in each juncture that any time there is a settlement, whoever has received money, whether they're a conservator or just a parent, hold the money for the benefit of the child under the code sections that impose a type of fiduciary obligation. So I know that probably doesn't go as far as you would like, Senator, but we tried to address the concern that we felt was a legitimate one on your part.
Okay. Because the Georgia law requires liability coverage of just 25/50, 25 per person. I would venture to say, certainly far more than 50% of all settlements would fall under your threshold now. But okay, I get it.
They could, and again, the idea is, while I believe, as I'm sure you do, Senator, that attorneys being compensated for the work is a positive moral good in society, not everyone sees it that way. So we're trying to make it where that can be accomplished without involving that expense and that time when there's a smaller amount, to make sure the money gets in the hands of the child. But I understand your concern.
Okay.
Any other questions from the committee? All right, Mr. Bob Bray, you can sit tight if you want. The Council of State Court Judges is here as well. You worked on this for the last year, I know.
Good afternoon, members of the committee. I'm Bob Bray. I'm the Executive Director for the Council of State Court Judges, and I just wanted to let you know that you should have a letter in your folders from Judge Greg Sapp that explains our support for the bill and gives a little bit more description about our support for it. That's all I had to say.
All right, any questions from the committee for Mr. Bray? All right. No one else signed up to speak on the bill. What's the pleasure of the committee? We have a motion to pass by Chairman Watson. Do we have a second? A second from Senator Kirkpatrick by committee substitute. Any discussion? All those in favor of the motion, please raise your hand. It is 4. All opposed? 1. And is Senator Calzert carrying the bill?
Yes. Actually,
I believe Senator Hatchett's carrying this one as well. Is that correct?
yes.
All right.
I had hoped Senator Calzert would, but after last year I realized that was a dream that was fast dissipated.
I know. Getting ahead of ourselves just a little bit, about a year, I think. But all right, thank you. You're on the rules.
Thank you, Mr. Chairman. Thank you, Mayor.
All right, that's all we have. With that, we are adjourned. Thank you.